Okay, I think Beth's here. I think we're going to get started. Again, for for those of you who've just jumped on, I'm Amy Jordan Wilkes. I'm a partner in the Labor and Employment Group in the Birmingham office, and I am joined by my partner Beth Shirley. Let her talk a little bit about what she does, but we're going to talk about AI in the workplace this morning. So, Beth, you want to introduce yourself?
Yeah, so as Amy said, I'm Beth Shirley or Elizabeth Shirley, and I practice in commercial litigation and cybersecurity and data privacy. And so I have certifications as a CIPP and CIPM, which basically means I'm certified to advise in data privacy and also data privacy management programs. So that's a unique area that also intersects with AI. So I'm going to be talking about that today.
Great. I'm excited to hear your knowledge on all things AI. So I think, the headline is AI is here. I know it sounds like something futuristic and something, that's way off, in the future and not something we really have to deal with. But according to a 2022 study from the Society for Human Resource Management, 1 in 4 organizations is already reporting using automation or AI to support their human resources activities. And 85% of those who are using AI say that it is saving them time and increasing efficiency. So, what is AI, Beth? What are we talking about when we use that phrase?
Yeah, so I'll talk generally about what AI is. Can you guys see my slides?
I can, yes.
Are they moving? There we are.
Yes.
Okay. So this is kind of a background quote about AI from Bill Gates, the co-founder of Microsoft. As you guys know, the development of AI is as fundamental as the creation of the microprocessor, the personal computer, the internet, and the mobile phone. It will change the way people work, learn, travel, get healthcare, and communicate with each other. Entire industries will reorient around it. Businesses will distinguish themselves by how well they use it. And so consistent with what Amy was talking about, it's here and it is a big deal. I don't think it's just a fad. Blockchain was, and well, I won't diverge the conversation into blockchain, but that had more of a fad quality with the cryptocurrencies and the great money that could be made, and then the breaches and the losses of money. So AI is not of that ilk. It's actually been around for a while. It first was conceived of back in the 1950s. And it has been developed since then, and it's been in use since the early 2000s, but in very rudimentary forms. So how does it work? AI applies logic-based techniques to mimic human behavior. So it essentially takes a data set, and every AI platform has a different data set. There's OpenAI, which is kind of like a chat GPT you guys have heard about. And that takes, anything. It's basically a huge monster that consumes information that it can obtain from the internet that people enter, any sort of information it can get a hold of, it consumes it and uses an algorithm to predict the next word and conclusion based on that publicly available data set. And so it is designed, that algorithm is, to mimic human behavior. Now, I said that there's open and closed systems. A closed system might be something that an employer may use, that an attorney may use. We have not started using AI, but we have an AI committee that is evaluating it. We want to make sure we fully understand the risks before doing so. But a closed AI system is where you choose the data set, or there is a specific data set in a particular field, and the AI works again with a logic human-based algorithm to pull data from that data set. So in my opinion, it's more secure than an open AI. We generally advise clients do not use open AI in your business because it may be receiving confidential information of your business, personal information of yourself or your employees or your customers. And that's, like I said, open AI is a monster. It's going to consume that information and use it as a training set. And that is inconsistent with data privacy obligations and, frankly, what you want to protect your business and its confidential information. So some of the AI that is existing right now are things that you're very familiar with, YouTube. So for example, if you look up a YouTube video, you might receive, or you will receive, recommendations and similar videos based on the content. So what the computer has done is taken the language that you used and predicted other areas that you're going to be, or perhaps are interested in. Siri and Alexa are AI based, and so is autocorrect and autocomplete based on your smartphone, right? Where the phone is guessing, sometimes incorrectly, what you are going to be saying next or what your word is. So I mentioned Chat GPT. One question I get sometimes is, what does that even stand for? So it's Chat Generative Pre-trained Transformer. Not very catchy, but neither is Chat GPT. As a title, not that I'm criticizing the product in any way, but it's rather a mouthful. But it's trained, like I said, on the internet data and the data that's input into it. And so anything that it can get a hold of, it will consume and use to train itself, which theoretically, if you apply that going forward, it should get better and better at predicting human logic, human thinking, and accurate answers. So it took 3.5 years for Netflix to get to 1 million subscribers. It took 2 years for Twitter to get to 1 million. And it took 5 days for Chat GPT to get 1 million users.
Wow.
So it's growing like crazy.
Like crazy, yeah.
Amy, did you want to jump in and talk about how it's being used in the workplace?
Yeah. So, how are employers using AI? And, I think for some employers and, after, listening to you go through what AI is, I'm not sure that, really all employers or HR people understand what AI is or even knew that they were using it. It's a much broader universe than I think, even before you and I started talking about this, than I realized it was. So, how is it being used? And I think the most common usage is in recruitment and hiring. And what am I talking about? So there are things like, resume scanners that prioritize and screen applications using certain keywords or skills or experience. You might get 2,000 applicants for a job if you're a really big company, or, it's a really a common job. So AI can help kind of scan those down to a more manageable pool. There are also, virtual assistants or chatbots, they're sometimes called, that ask job candidates about their qualifications, kind of a chat format, and then reject those who don't meet predefined requirements. The other thing we're seeing is video interviewing software that evaluates candidates based on their facial expressions and speech patterns to determine if they're a good fit for your company. And then, something I've seen a lot with kind of application software and onboarding software like Talent Reef is they do testing for applicants that provides what they call a job fit score that takes into account personality questions, aptitudes, cognitive skills, kind of cultural fit questions, and it spits out a score. And it's supposed to help, inform you as to whether that person's going to be a good fit in your organization. So, recruiting and hiring, that's probably the most common way it's being used currently, but also people are using AI for streamlining onboarding of new employees and also training. virtual assistant can guide your employees through the onboarding process and completing, all the forms and paperwork that come along with that. And also, assisting with training for current employees. The virtual assistant can create a learning plan for each individual employee based on their own individual skills and experiences, and kind of set a training map for them, and also give them regular follow-up on next steps. So I think that's exciting for large organizations, and being able to give that kind of targeted feedback and training to employees rather than a one size fits all approach. The other area that we'll talk about later has some real kind of pitfalls, but is interesting, is performance management and employee engagement. There are AI tools that can track and analyze employee productivity based on things like keystrokes, the number of emails you send, how often you're engaging with coworkers, like work patterns, how often you're logging in. And I know, for a lot of us, the thought of our employers being able to track our keystrokes and the number of emails we send, and how long we're logged in and who we're talking to, is a little bit terrifying. But that can give some really good insight to your employees and how productive they're being, and how they're spending their day. So kind of the flip side of that is employee engagement. Not just how productive they are, but how engaged they are in your business as a way to improve retention. So there are, automated collection of survey information, getting employees to answer little, quick surveys and questions, and gathering and that data in an anonymous fashion. Can give you some real insight into how your employees are feeling about their jobs and their duties, and kind of, the direction of the company, and where they see their career path. There are also programs that use algorithms to match employees with, certain projects or mentorships or learning experiences based on their particular skill set, as a way of increasing employee training and engagement and commitment to your company, and kind of long-term planning for success for your employees. One other thing I've seen is software that can scan employee communications for certain buzzwords that might indicate that they're dissatisfied or are considering leaving. So it's a really powerful tool to monitor what your employees are actually doing, and how they're engaging with each other and with the company. And the last thing we've seen is kind of this, generative AI tools that can help automate some HR functions. Tools that can help drafting basic job descriptions, policies, handbooks, leave documents, things like that. I think the important thing to remember with anything like that, you obviously are going to want a person at the end who reviews that job description, that policy, that handbook, to make sure that it actually tracks with what you're doing in your company. But there are also chatbots that can help employees, with benefits questions, leave questions, pay issues, just basic things like that. It's a way to kind of streamline and reduce your HR staff. So those are the main ways. Obviously, there are others, but those are kind of the high points of how AI is being used by employers.
Thanks, Amy. And those are good examples of really the advantages of AI put into practice. The advantages kind of fall into categories. So it eliminates human error and risk. People can make mistakes, get distracted, get tired, and that's gone with a machine. It can work 24/7, and it's available 24/7. No inconveniences, no sick days, no vacations, nothing like that. It just goes. Ideally, it's an unbiased decision-making process. The reason that's in parentheticals in the PowerPoint is because the AI is an unbiased algorithm theoretically. I mean, assuming it's written like that, but it is based on an existing data set and an increasing data set. That data set is not and cannot be without bias and prejudice because it has been created by people, right? So that's something that we'll talk a little bit more about and that we're seeing come up in some court cases. And Amy will talk in particular about some EEOC issues. But AI can also perform repetitive jobs without getting carpal tunnel or tired or complaining. And there's cost reduction, right? It's cheap. You invest in it and then it's done. And it can process and analyze large volumes of data. That's another amazing thing. There's a legal AI tool that we were looking at. And what it can do is it can take all the depositions in a case, all of the law that you have included in your briefs and that the other side's included, and it can say that's the data set. And then it can take your brief if it has no citations, no references to law or the depositions, and find it and dump it in, right? Dump it into your brief. And, it has to be checked by a human, as Amy said, to make sure it's accurate. But that's an example in our field of the sort of vast consumption that AI can make, or vast processing of information. And it takes humans a lot longer. So the risks of AI, hallucinations. You guys have probably all heard about these. And the now famous instance of an attorney using ChatGPT to write a brief, and ChatGPT made up case names that never existed and case holdings that never existed. So there have been some knee-jerk reactions by some judges around the nation that say, if you use ChatGPT, you have to say so in a certification, every filing that you make with the court. That would be not good practice. Even if one uses, though, AI that is more in the legal field and has a closed set, that's something to put human eyes on afterwards just to make sure. So the bias comes in the form of what's in the data set, as I mentioned. And one of the foundations, or one of the sources of data for ChatGPT, is Reddit. And Reddit is a bunch of opinions, right? I mean, it's not, maybe it has some facts, but it has a lot of opinions and some mean opinions. Actually handling a case where someone has repeatedly been harassed and defamed on Reddit and they can't get it to stop. So this is the training set for AI, or for some AI sources.
Wow.
You've got to be really careful about how you use it. What happens to the input data? As I mentioned, it's like a monster. It consumes it and gets stronger by your data. So be very mindful of that when using it. I think that our policy here is currently nobody is allowed to use ChatGPT on any company computers, devices, nothing. Or, of course, use any information regarding work on an open AI. Another issue is potentially replacing the employee's judgment in the workplace, right? So you don't want to over rely on it. Again, as Amy mentioned originally, you need that human oversight to second guess any sort of judgment calls that this AI you may be using is making. And will it replace employees in the workplace? That's always the question that comes with the new technology, right? It might replace some employees with very basic jobs that have repetitive functions. But, we saw that happen with factories, right? I mean, some people's jobs were replaced, but I don't think it's going to be a devastating wipeout of employees where, we're going to be dealing with essentially robots, not robots physically, but, machines instead of employees. So here is a particular case that I'll deal with. And I think, like I said, Amy's going to go into more detail here, but recently the EEOC settled the matter with ITutor Group for $365,000 consent decree. Not too bad, considering what it could be. But basically, ITutor Group was a company that hired tutors to provide English language tutoring to adults and children in China. and the sole qualification was a bachelor's degree. So anyone could be qualified to do the job if they had a bachelor's, but it automatically rejected female applicants over 55 and male applicants over 60. And that was just based on the programming. So I don't know if that was intentional in the programming of the algorithm, but it's the effect. And so that can happen based on, you know, what the data is trained on. So for example, another instance is there was racial bias in AI that was intended to improve access to care for high-risk patients with chronic health problems. Great goal. And so an algorithm was based on the data set of patients' past medical costs to predict their future ones. But unfortunately, it didn't account for the fact or the statistic that African Americans historically have had either unequal access to medical services or a distrust of healthcare providers in light of Tuskegee and other matters. So again, that was a data set that gave unhelpful results and can even be discriminatory. And then the last one I'll cover before I turn it back over to Amy is Amazon used AI recruiting program. And I know that she discussed that as one of the many AI tools out there for employers. But the program model was based on a data set by looking at patterns in resumes submitted over a 10-year period. That doesn't seem on its face to be a problem. Unfortunately, the majority of candidates were men. And so the AI concluded that men were preferable to women in the job position. So, you know, again, the data set's what's so important. And, you know, the question then becomes, how does a company, an employer, figure out whether the AI they're, you know, hiring a company to use or retaining, you know, getting their vendor services in has that?
Right.
Go ahead.
Yeah, and one thing I think is interesting about the ITutor Group that's case that the EEOC just settled a few weeks ago, the issue with that wasn't discovered, you know, by the employer. The EEOC just didn't investigate and find it. It was discovered when one applicant submitted 2 applications that were identical, except for the date of birth. And the first application had a real date of birth on it. And the second one had a younger age, and she was only contacted for an interview after she submits the second application with a younger age. So, you know, I think that's important because, you know, applicants and people out there looking for jobs, you know, they know about this. And they know that if they're applying for a job, you know, particularly with a big company, that there's probably some sort of AI that's involved. And, you know, I think increasingly they're going to be testing the system for these types of, you know, kind of gotchas. So it's, I think, you know, that's a real risk that people are looking for this now when they're applying and not getting jobs. So I thought that was kind of an interesting fact about how that kind of case came about. So I want to talk a little bit about, you know, AI and the risk, the legal risk for employers from an employment law perspective. So monitoring the use of AI is a priority for the EEOC and, you know, other federal agencies. They've actually done some joint stuff with DOJ. But and back in 2021, the EEOC launched their Artificial Intelligence and Algorithmic Fairness Initiative to ensure the use of software in hiring and other employment decisions complies with federal employment laws. And since then, they've made it part of their strategic enforcement plan. In fact, just last week, the EEOC released their strategic enforcement plan for the next 4 years. It's all the things that they're going to prioritize when they're enforcing all the laws that kind of fall under their purview. And one of the things, and I'll just read you what they said, is recognizing employers' increasing use of technology, including artificial intelligence and machine learning, to target job advertisements, recruit applicants, and make or assist in hiring and other employment decisions. So this is a priority for them. It's, you know, kind of a buzzword all over. The EEOC is not going to, you know, take themselves out of the action. I think we've seen with this recent settlement, it's kind of the first one. I think it's just, the tip of the iceberg, and they're going to get going on this. So part of their strategic initiative, the Artificial Intelligence and Algorithmic Fairness Initiative, part of that initiative was they're going to put out, webinars and Q&As and guidance for employers on, how to use AI and what the risks are and what they need to be looking out for. So in the employment law context, we always think of disparate treatment, right? Intentional discrimination. Less common, I think, for most people is the flip side of that, and it's disparate impact. And, when I talk about disparate impact, what I mean is you can't use a neutral test or selection procedure that has the effect of disproportionately excluding people based on race, color, religion, sex, age, etc. So earlier this year, particularly in the disparate impact front, the EEOC issued some guidance for employers in the form of Q&As. So here are some key points. They point out that a selection process that uses AI could have a disparate impact if the selection rate of individuals of a particular race, gender, national origin, etc., or a particular combination of those characteristics is less than 80% of the rate of the non-protected group. Okay, so that's the one part. The flip side of that is unless you can show that the use of the AI is job related and consistent with business necessity, which means the AI that you're using, what it's screening for, you're actually looking for skills that relate to the job that you're hiring for, and there's no less discriminatory tool that can be used. So I'm using this AI, it's related to the job, it's targeted, and there's no other system in place that we could use for this hiring and recruiting process. That's kind of how you get out of that disparate impact track. So some kind of examples of where we could see a disparate impact. So there have been some studies that show, I think I talked earlier about the video interviewing and facial recognition software. There have been some scientific studies, particularly in the context of law enforcement, that have shown that facial recognition software sometimes has difficulty distinguishing people of color from one another, which has led to issues with false arrests and things like that. So if facial recognition software is used in the hiring process in these virtual interviews to kind of screen people for whether they're a good fit, whatever that means, and if the software is less capable of reading facial expressions on individuals with darker skin tones, those individuals could be disparately or adversely impacted unintentionally just because of a flaw in the software. Another kind of aspect of that is if the software is designed to analyze speech patterns to reach conclusions about an applicant's ability to solve problems. An applicant could be scored unfairly if they have a speech impediment or an accent that causes significant differences in speech patterns. Again, these are all, unintentional biases that are coming in the system that could unintentionally be disparately negatively affecting certain groups. Another example is a chatbot. It's programmed with an algorithm that rejects all applicants based on anyone who has a significant gap in their employment history. That could screen out someone that had a disability if the gap was caused by that disability. For example, they needed to stop working for a while to undergo some sort of treatment. Those people would be screened out unfairly based on their disability. I've got a couple more outside the recruiting context. So if you had an algorithm that was measuring productivity and it was measuring keystrokes, you didn't tell employees that this is how you're measuring productivity. If you have a visually impaired employee who's using voice recognition software instead of a keyboard, therefore they're not doing keystrokes, that employee may be rated poorly. That's a specific example the EEOC has given in the context of disability discrimination of where AI can have a disparate impact. So the last one, and this was one I hadn't really thought about, but if you had an applicant rating tool that maybe identified candidates who, graduated from school after a particular date, or maybe even had a .edu email address that could lead to some unintentional bias against older candidates. So, those are just some examples of how, you need to think about kind of outside the box about disparate impact and how the programs that you might be using might have kind of an unintended consequence. So the other thing the EEO said, look out for disparate impact, but they are encouraging employers to proactively self-monitor and analyze the systems you're using to determine if they have a disproportionately negative effect on protected groups. Now, it's a little bit difficult because, I think a lot of people don't necessarily know how the technology works. They don't know what factors are being considered, what the system is analyzing, the data set, as Beth would say, and how do you get that information? A lot of the systems, the platforms, how they're set up, the companies may, consider that to be proprietary. So that's really, I guess, kind of a big burden the EEOC is putting on employers to really, know what you're using, what AI is involved and how it works, and how it's actually affecting employees and applicants in the real world. I know, Beth, do you have anything on self-monitoring and how employers can kind of figure out how what they're using is working and impacting people?
I was just thinking about, as you said that, I can see in the future that when AI vendors or providers are offering a tool, they are required to disclose some basic elements about, the target areas that the AI functionality is looking at, right? I mean, that currently doesn't exist. I would think that would in the future. I do know that, to the extent AI is dealing with any personal information of a company, like of its customers, of its employees, then the company needs to make sure that it has an agreement in place with that vendor where that personal information is protected to the same level as the employer is obligated to protect personal information. Now, is that a requirement in Alabama and throughout our footprint? No, it is a requirement in, I think it's 12 US states now. And Tennessee passed a data privacy law, as well as Florida recently. They have not gone into effect yet. So those would be the states in our footprint that have data privacy laws and do require those sort of agreements. But even absent the requirements from law, I mean, it's the best legal practice. The FTC recommends it. Is it a law that you're going to be breaking? No, not that I'm aware of. But if you have zero oversight of provider, an AI provider otherwise, and you're sharing personal information and something terrible happens, meaning there's a breach, right? And there's significant harm to the affected people, then you're going to be dealing with, California data privacy laws. If any of those people are residents of California, and you will be dealing with, potential class action. I think California is still the only state that has a private cause of action allowed for violating its data privacy law. All the other 11 that I mentioned do not. It's only enforced by the Attorney General.
Yeah, well, and I think, being, responsible for the vendors you use and having to oversee them. I mean, the EEOC has said in their guidance that employers are responsible for the disparate impact caused by the use of AI that's purchased or administered by a third-party vendor, even if that vendor has told you, hey, we've analyzed this, it's great, it doesn't discriminate, which I've seen some AI vendors out there who are definitely touting how wonderful their system is, and they've checked it and you don't have to worry about it, and just hit play and you're good to go. And the EEOC is saying, no, you're not off the hook. You have to monitor this. You have to see how it actually is working in practice. And you, the employer, are responsible if what that vendor has told you turns out not to be true. So, I mean, I think that's, that's kind of a difficult thing and something, employers are really going to have to keep an eye on.
Yeah, yeah. Another interesting development is where companies are using AI. California has is looking at draft regulations. It's issued the draft regulations, but they haven't been implemented and adopted. But those regulations would require what's called a data privacy risk assessment for using AI in the context of certain categories of personal information, such as, I don't know, sensitive personal information, which means facial recognition. Anything that involves genetic or biological or other imaging identification of people.
Yeah. Well, so one other thing I wanted to say about the EEOC before we talk a little bit more about privacy concerns is, what the EEOC says you should do if you're using AI for recruiting and hiring is that you should be upfront about it with your applicants. You should tell job applicants or employees that are undergoing assessment with an AI tool as much information as possible about what you're using. You should tell them, what the program is, what traits and characteristics the AI tool is designed to measure, what methods those traits and characteristics are going to be measured by, the characteristics, the tool is going to be looking at, whether there are any disabilities that might potentially lower the assessment results or cause screen out, like, for example, the visually impaired employee that I mentioned earlier. And then also clearly communicate to employees or applicants, reasonable accommodations, including alternative formats or alternative tests that might be available to people with disabilities, and clear instructions for those people to request those reasonable accommodations. So, I think that's something that we all need to go back and look at our hiring processes and our to the extent that any AI is being used to measure productivity or employee engagement, what kind of disclosures are we giving employees? We're used to having all sorts of disclosures on applications and, software and things like that, with what we're using and what we're collecting. I think that's just a common part of the employment process, but now you've got to expand that out and say, okay, here's a tool we're using, here's how it works, here's what we're looking at, and here's how you might be adversely impacted if you have certain characteristics or disabilities, and if you need an accommodation, here's how you request it. I think that's not something I've seen on a lot of kind of standard application or recruiting software.
Yeah. So I think that the EU has done a pretty good job of summarizing the overarching areas that should be considered in evaluating whether you use AI. And the EU is pretty advanced on data privacy protection, even more so and aggressively than California. But nonetheless, I do think that these principles are sound principles. I'm not always going to the EU to apply standards to the US because the laws are quite different in data privacy. But human agency and oversight, this is something we've been talking about the entire time, right? If you're relying on AI, you've got to have some people who also put human eyes, mind, judgment on it, because AI doesn't have judgment, right? That's a personal thing. Some people don't have judgment in my experience, but yeah, so you want someone with judgment and reasoning and just kind of a sense of, wait a minute, this is the law, or I'm familiar with this, this isn't right. So technical robustness and safety, this is more of something from your IT group, right? You want to make sure that AI is implemented with security, meaning there are no open pathways such that there's insecurity between the AI and the company system. And then, with regard to the agreements we mentioned earlier between a company and a vendor for sharing personal information, or really any company information too. You don't want your confidential information out there. You want to make sure that the AI provider is one that is more established, you've heard of, you've done some research into, not just, your your employees, friends, new business idea. Although that may turn out great, but it, you know, if you're working with it in your company, I want some track record. Privacy and data governance, again, we've been talking about this. You want to make sure that the AI system you're using is ideally closed-ended and that it is not violating people's data privacy rights. And what I mean by that is using their personal information for purposes other than what they provided it for and without telling them. Those things are bad ideas according to the FTC and not permitted according to the state laws that have data privacy laws. Transparency. This is something I'll talk about a little bit more in the next slide, but you want to tell people what you're doing, right? And I think Amy's examples really lead to that conclusion. So, you know, if you are going to make a decision based on a gap in work experience, you know, tell people that. So someone who has been dealing with a disability can let you know, hey, you know, I wasn't just sitting around unemployed. I had a, you know, physical problem, mental problem, whatever it was. They don't have to specify, of course. Diversity and non-discrimination and fairness. We've been harping on this, you know, that kind of permeates a number of areas you want to monitor to see if, you know, all the applicants you're getting, hey, they're all, you know, of a certain race and gender. This seems odd, you know, those sort of things. You'd want to pay attention to that and not just say, well, AI has its ways, you know, it's got the algorithm and that's that. Environmental and societal well-being. This is more of what I'd call an EU typical factor, because, you know, the well-being of people is one of the central themes in GDPR, right? What's furthering the legitimate interests of people and protecting their human rights. And so I think the notion here is that when you have AI, especially as mass implemented, that is not making decisions that have oversight for bias, it's creating a negative environment for people and for society. And then accountability, you know, don't just observe and do nothing. Hold people and AI systems and vendors accountable if something is wrong. You've got to implement some corrective action, not just do nothing. Okay, so for purposes of transparency, like we were talking about, Illinois has passed an AI law that requires notice and consent to use AI in the hiring process. Now, there's been much discussion about what if someone doesn't consent, you know, do they not get to apply? And I don't have an answer for that. I would think the answer would be no, they get to go through another method, but that's been discussed in the legal community. Deletion rights. So if someone applies and, you know, they don't get the job, they get to make a demand. Hey, delete all my personal information that you collected. You don't get to keep it. You know, the company doesn't get to keep it for AI training purposes or its records. And then the companies have to report annually on a demographic breakdown of applicants that they offered an interview, those they didn't, and those they hired. And that's an effort really to keep the AI accountable. And then in New York City, you have to do a bias audit of AI and automated employment decisions with the results publicly available. And this went into effect earlier this year. So New York City is a little unique and it's not throughout the states, but you know, these are the sort of concerns and ways that states are addressing AI so far in the use of companies and with employees.
Yeah, and the Illinois law is interesting. I'm sure, you know, most of you on the call are very familiar with BIPA, the Illinois Biometric Information Privacy Act. It got a lot of, it's gotten a lot of coverage and news with, especially with the fingerprint skating time clocks. But there's been just, explosion of litigation under BIPA. Really, the Illinois Supreme Court took a very expansive view of the statute of limitations for those claims. But there have been increasing complaints under BIPA related to the use of AI and facial recognition software and things like that. So, the fact that they've got the, Illinois again kind of got this law, I think it'll be interesting to see what other states adopt similar laws, and is there going to be a similar explosion of lawsuits under laws like that? So, yeah, that's definitely something to keep an eye on.
Yeah.
All right, so we have about 13 minutes left. I think we allocated this time for questions. I don't see any questions in the kind of chat question box. So if anyone has any questions for us, you can go ahead and type those in and we will take a stab at answering them. But if there are no questions, we'll wrap it up. And if it comes to you later, you've got contact information for me and Beth. You can always give one of us a call or shoot us an email and we'll be happy to answer it.
So Amy, I have a question, and
Sure.
You may not know, but when you were talking about the EEOC guidance on the use of AI, I'm trying to understand the recommendation or guidance that a selection process that uses AI could have a disparate impact in violation of Title VII if the selection rate of individuals of a particular race, gender, national origin, etc., or a particular combination of those characteristics is less than 80% of the rate of the non-protected group, unless they can show AI that AI is job related. So I presume then that 80% would be viewed in the context of the proportion of applicants, because I mean, you can't assume that it's going to be equal applicants of protected and non-protected groups, and that if protected groups are less than 80%, there's a problem, right? I assume it would be adjusted based on the percentages in the scope of data that's being considered. Do you know?
Well, the 80%, that's just kind of the general disparate impact. That's or they sometimes refer to it as the 4/5 rule. And again, if you start asking me math questions, it's going to break down because I went to law school because I'm terrible at math. I'm going to stick with the 80%. But yeah, I mean, I think you are looking at the data set. But as with all things EEOC, their guidance is vague, and they'll just throw out a Q&A and kind of leave some little nuggets of information and then leave employers to figure it out. But yeah, I mean, I think it would obviously have to be tied to the data set as a whole.
Yeah, and I guess that would make sense if it's consistent with the rule that's applied outside of AI. So basically, they're just taking a rule that's applied for disparate treatment or
disparate impact.
Yeah, disparate impact, and putting it in the AI context and saying it applies here too.
Yes.
Okay.
That's my understanding.
I was trying to understand how that worked, and that is helpful for me at least.
Yeah, it looks like we have one question, and Beth, I think this is probably one for you. I don't know if you can see the Q&A, or if not, I'll read it to you.
Yes. So the question is, what risks have been identified when using ChatGPT on work computers? Does it access private and proprietary information when accessed from a company computer? So I believe the answer is no, it does not. It accesses what you input into it. It's not something where you put it on your computer or pull it up on your computer. It's free on the internet, and it is able to access other data outside of what you put in. But the concern for companies and employers is what people put in. right? They might not think they're putting in confidential information, but even if they try to make it anonymous, they might be putting in, a factual situation with different names that when they do other searches, could be put together to identify a real situation or real information. So, yeah, I think the answer to the question though would be no.
Okay, that's interesting. And I guess that, explains why, companies like Burr have banned the use of ChatGPT. It's not that it's mining our computer system and our confidential client information. The concern is that the user might inadvertently or, unsuspectingly put information in that's confidential that then goes, the monster eats it up and it becomes part of the system.
Yes, that is the concern. And it could be used to train other AI. And I think Zoom was trying to do that, but then people had a fit about it and they deleted that policy, but they were going to use recorded Zoom if you consented to train their AI. And that came to our attention and everyone was all upset about it. But like the next day that notion had gone away. So
yeah, okay. So the takeaway from this is that those in those user agreements that everyone scrolls through on software, just scrolls and click accept. Maybe we should look closely at those.
Oh my gosh, I can't tell you how closely you should look because they're one-sided agreements, right? I mean, they're just something that pops up on your computer. And I'm not saying that makes it, a contract of adhesion or unconscionable, but that's the truth. It's what the website company wants you to agree to. People just check a box and you have no clue what you've agreed to. You probably agreed to jurisdiction in California. You get no damages, or you get $5,000 of damage and you have to go to arbitration. I mean, you never know. And so I actually do a lot of work in that area and the enforceability of those agreements, as long as they are posted in an open and obvious manner and not hidden at the bottom of a page and in a, the same color font as the background of the website where people can't see it unless they're fly specking the website. I mean, they can be enforceable. But the reality is nobody wants to read those. I mean, you're on a website, you're trying to do something fast because that's how the internet produces information. And people who want information fast go to the internet, and nobody wants to read them or bother with them.
No.
But they can be.
Well, I don't see any other questions. I don't have any other final thoughts. Beth, anything else from you?
Nope, that is it.
All right. Well, thank everyone for joining us. I hope you learned some good information about AI and we didn't scare you that the EEOC is going to come and shut down your whole business if you use Talent Reef or some sort of electronic onboarding software. You're good. Just pay attention. But if you have any questions or any follow-up, or if you get, you start poking around and looking at what services you're using and you have specific questions for us, you want us to take a look at it, of course, happy to do it. Reach out. You have our contact information. And I think that's it. So thank everyone again.
Thanks for joining us.